Good morning. Thanks for joining me on hour 3 of the Meg Ellefson Show. Very happy to have joining me from our great friends at Wisconsin Institute for Law and Liberty, standing up for our freedoms and liberty here in Wisconsin and beyond. Attorney, Will Education Counsel, Cory Brewer. How are you, Cory?
Good morning, Meg. Thanks for having me. I'm doing well.
Well, thank you for joining me. I appreciate it on this Friday Eve, I like to say. We were chatting about, well, the anticipation of the weekend is almost here, so that always puts a smile on my face. It's not sunny here in Wausau, but how about where you are? You're down in Milwaukee area?
No, it's pretty overcast here in Milwaukee as well.
All
a little
right.
bit gloomy.
Yep, we're sharing a mutual glumness. But I always say it's always warm and sunny on the inside. So let's talk about, and this isn't warm and sunny, of course. However, I'm grateful. I talked with one of your colleagues this morning during the Wisconsin Morning News, Dan Lennington, and I said, well, there's an awful lot of job security in your business right now because of the egregious acts of our elected officials and beyond, and this radical agenda that they're trying to thrust upon the American people. You filed and I was asking you before, my non-legal jargon, amicus brief in the United States Supreme Court. You just filed that just this week, correct?
We filed it about a week ago,
Okay.
but yes, we put out a press release this week to let everyone know what's going on and why this is important.
Well, let's talk about it because, of course, many of us, most of us, at least those that listen to the show, I talk often about the rule changes that were proposed by the Biden-Harris administration, the Title IX rule changes, and how it will affect women and girls here in Wisconsin and throughout the country, and specifically girls that want to participate in sports. And I mean, I've often said, Cory, how frustrating it is that I don't hear, I mean, it's like crickets. I don't hear a sound from feminists at this point, and how there's this war on girls' sports, this war on women's sports and privacy and decency. And I think I'm grateful, again, that Wisconsin Institute for Law and Liberty is standing up on behalf of girls and women in sports. So specifically talk about how this is, well, I guess I know that there are the Title IX ruling that the Supreme Court just made. And, you know, if you can clarify that to begin with, and then I guess then segue into this amicus brief that you filed last week.
Sure. I'll give a little bit of an overview of what the most recent U.S. Supreme Court decision was. I'll talk about how that new rule impacts or doesn't impact athletics, because there's not a lot of clarity there. And then I'd be happy to talk about the brief that we filed as well. So as a lot of your listeners probably know, Title IX is the federal law passed by Congress. It prevents discrimination on the basis of sex in educational programs. So in schools, pre-K through higher ed, it doesn't matter. And really what most people think of is athletics and kind of just overall opportunities and rights of women and girls in education. And what the Biden administration has done is they've now finalized, and it's in effect now as of August 1st, if you're not covered by an injunction. So there's a lot of layers to this, but what they did is they enforced this new rule that changes sex discrimination to be defined as basically discrimination on the basis of gender identity, sexual orientation, sex stereotypes, and we think that actually does the opposite of what the law is intended to do. And a lot of groups across the country feel the same. So there is litigation challenging this new Title IX rule happening all over the country. And what the most recent United States Supreme Court decision did was basically a few of the federal courts where those cases are being litigated, they granted preliminary injunctions, which basically means that the rule is paused. It cannot be enforced or implemented by the federal government while the litigation is ongoing. as to the parties in the case. Or there's a Kansas case where the injunction is a little bit more broad than that. That's referred to as kind of the Moms for Liberty Young Americans Foundation case. But it's on pause. And the federal government, this has gone kind of up through the appellate court and then eventually made it to SCOTUS. They said, hey, can you unpause this while we continue litigating? We want parts of this rule to be able to go into effect. And the United States Supreme Court actually agreed with the lower courts and said, no, we think these pauses are proper. They're going to stay in place. So at least in those cases, and those involve the Fifth and Sixth Circuits, so not Wisconsin, at least in those cases, the pause is still in place. The federal government can't enforce that new Title IX rule. So I don't know if there are any follow-ups on that before I turn to athletics specifically.
Well, I guess I have heard from a listener in the D.C. Everest School District, which is here in our listening area. It's the kind of Weston, Rothschild, Schofield area, and there was a decision made at the school board level that evidently the school board has voted, and I have very limited details, but they've voted to, as far as I understand it, they've voted to implement the Title IX changes in that district.
Yes, so I don't know the specifics with regard to that school district, but I will say that this new rule is there are policies consistent with this new controversial rule being passed all over the state, and they if it's urban, if it's rural, if it's small, if it's a big school district, a lot of these school boards are feeling pressure to implement. And our friends over at the Southeastern Legal Foundation are involved with the litigation happening in Kansas involving Moms for Liberty. They're a great resource in terms of what the injunction in that case means. But essentially, if you are a Moms for Liberty member and your child attends a school in Wisconsin, you can go on their website and make sure that that school gets added to a list that then gets submitted to that court. And as long as it's on file with the court, then the federal government can't enforce the rule against that school. So it's important to go through the process, get it on the list. And I think what's important here is that the federal government is the one that's prohibited from enforcing the rule. I suppose a local school district could still pass the policy if they wanted to. I don't see a lot of benefit to that personally, especially while this litigation is ongoing and it's all playing out. But we're seeing parents, communities start to pay attention more and more to this, and they're realizing, wait, if you put this policy in place, does that mean that a student can use a bathroom based on gender identity, a locker room based on gender identity? Does that mean that my child, if they don't use another student's preferred name and pronouns, could they be compelled to do so or otherwise face a Title IX sexual harassment claim? Yes, the new rule, we think, does impact all of those areas. And parents are starting to say, we don't want this in our community. And that's just kind of the practical reaction, but we think that it's unlawful as well. So we're following this litigation very closely. We're not litigating it right now, but we will likely weigh in soon with, again, another amicus brief kind of supporting the opposition to this new rule.
So how do you instruct school districts, school board members, and even concerned parents that, in particular in the D.C. Everest School District, it sounds to me as if right before the beginning of the school year, these are the changes that they're implementing. And I mean, what if a concerned parent who has a daughter that plays in athletics is now forced to have to compete against a biological male? What's the recourse for a parent in this case?
Mm-hmm. Yeah, no, it's really complex. I think from the school board perspective first, we have a resource on our website. If you go to schoolboardpolicies.org, we have a short resource that is kind of an FAQ on this new rule. And I think it emphasizes a few things. First, you should understand what Title IX is and what this new rule does. Second, you as the school board are authorized to make the decision. Not the superintendent, not the legal counsel, not any private company that's providing the policies. You as the school board make this decision. And the other thing that we've been really emphasizing is there's risk on both sides. If you do implement the new policy or if you don't, there's risk on both sides. So it's not like saying, oh, if we implement this, we're safe. No, there are actually risks even if you do implement it. If you don't implement it, maybe a transgender student could sue the district and say, we think you're discriminating and you should be following this new rule. But if you do implement it and you go with these really extreme changes, you could have a parent, or like what we're representing in this girls' sports amicus brief, a parent association who's concerned about the privacy and safety and opportunities of girls. You could have a lawsuit on that side as well. So don't think that by implementing this new controversial rule, all of a sudden all litigation risk is taken away. It's important to understand all the moving pieces, all the content, and that there's risk on both sides.
Well, and I guess I would say to a school board member, damned if you do and damned if you don't. But, I think, I guess it would behoove them to take the advice of the United States Supreme Court and agree to a pause at this point. Wouldn't that be the prudent thing to do?
Again, it's not without risk, but yeah, I think that would be a reasonable approach to watch what happens in the litigation. There's a whole other issue about existing case law to be mindful about. So there's some cases in the Seventh Circuit that impact Wisconsin. So understanding those case law decisions and the new rule and how they interact with each other, which one in the Title IX litigation impacts and which it doesn't, I think that's all important to understand. But yes, I do think given that this rule is enjoined in about half the country, the United States Supreme Court in its recent decision, although it was not a decision on the merits, it did not halt the entire rule for the whole country. They did say that all 9 justices actually agreed with the pause as it relates to the sex-separated facilities, the new standard for sexual harassment, some of the most controversial parts of this new rule, they actually all agreed on, which, looking at it optimistically, could maybe tell us something about how they'll view this when the full case does get back up to them.
Well, so let's talk specifically about this amicus brief and what you are attempting to accomplish.
Yes. So we filed a brief in a case called State of West Virginia versus BPJ. And this case is about sports specifically. It doesn't necessarily concern this new Title IX rule, but rather it concerns some lower court decisions that have interpreted Title IX to include gender identity and basically say excluding a student from a sports team that they want to play on based on their gender identity, that could be a violation of Title IX. We think that's wrong. We think Title IX actually explicitly permits sports teams separated by sex. It was intended to give women and girls opportunities to be mindful of their safety, to be mindful of their, all the benefits that come from athletics. And the United States Supreme Court has not taken up this case yet, but that's basically what our brief is kind of requesting that they do, saying this is a really important issue. There's a lot of confusion in lower courts. We think some of those lower courts got it really wrong, and we want you to weigh in, United States Supreme Court. Please weigh in on this. Please clarify that sex in the context of Title IX doesn't include gender identity. So basically, we're representing this parent association who cares about girls' sports, and we're saying, Supreme Court, please take this case.
I was thinking about, Cory, is that so the statement you just made about excluded from sports teams because of their whatever gender identity. This this could this could be a slippery slope. I mean, and just roll with me for a second. But what if so? This might be just the very beginning of I guess lawsuits with regard to those that are and I mean, let's face it. You and I know that men's sports, boys' sports will never be affected by this decision. It's only girls and women's sports that are ever going to be adversely affected. But, however, if the term excluding someone from a sports team because of their whatever identity, sex identity, what if someone decides, well, I want to play on a sports team, but I have no athletic ability. I mean, what's going to prevent them from not using this same argument? Well, there are qualifying factors. You have to exceed, or you have to excel in a certain sport in order to play. I mean, don't you think that this could lead to a very slippery slope?
Yeah, I think in the context of that kind of, this is a little bit less legal, but it's something that I've been hearing frequently, especially in the K-12 space, is inclusivity. We need to be inclusive, and kind of focus on including everyone. Their feelings matter. Well, one of the things in this case, this BPJ case, some of the lower courts actually discussed the feelings of the transgender student if they weren't allowed to play on the girls' team or compete against girls. Well, what about the impact on girls? That seems to be the question that not a lot of people want to address. This impacts girls too. And if there's a boy on the girls' team competing against girls, winning awards, going to conference championships, that means that at least one girl isn't having that opportunity. So what about that? And it doesn't seem like people want to really talk about that. But I think that's a really, really big problem. And frankly, most people actually agree with this, that girls should have these opportunities. It's something when you talk in the community, when you look at polls, it's very widely supported that girls' sports should be kept separate. So we would just really like to see some clarity from, on the legal side that the way it should be.
Well, and I don't know if you've seen this report. This was on the Daily Wire just a couple days ago. There is a trans identifying golfer. I'll just put it plainly. A dude that wants to play golf against women. Evidently, he at one time played on a men's college team and was just, well, mediocre. So he's decided that he wants to compete against biological women. And I've heard people say, okay, don't even use the term biological woman, because I mean it's to the point now where I don't know. I mean, what is the terminology that we can use? XX and XY chromosomes. I hear this mantra: XY, you're a guy, and it's frustrating because this particular individual will most definitely, because of his male body, he will take an opportunity away, a competitive opportunity away from a woman that wants to participate and wants to obviously aspire to get scholarships and awards, etc. And this is something that now he's being allowed to do because of his mental illness that he has.
Yeah, I mean, plain and simple, it's not fair. And we at Will we've always acknowledged that, yes, gender dysphoria is real, and it is something that should be considered if a child is truly struggling, if an individual is truly struggling. But to immediately affirm and to force others to immediately accept, that doesn't help anyone. And my colleagues, Dan Lennington and Lauren Groyle, they actually just published a piece in National Review about Title IX in the Olympics. Look at all these college athletes that have benefited from Title IX, and now they're women that are able to excel in the Olympics. And people are watching, they're paying attention, they're excited about this. And then you have lower court decisions in some parts of the country. You have the Biden administration putting forth this new rule that would really just turn all of that on its head. And we're happy to be fighting back against it.
Going back to, I can't let this go, Cory. Sorry, but this male golfer who calls himself Haley Davidson, and as I said, formerly played golf on a men's college team, mediocre at best. He actually recently won the NXXT Women's Classic in Florida, and then NXXT Golf announced they would change the rules to disqualify males. However, he did this male named Haley Davidson. He did write on Instagram, "I will never understand athletes who blame a transgender competitor on their own athletic failures. If you don't take accountability for your failures, then you will never actually be good enough to make it." So essentially what he's saying is he's discounting the fact that he has an unfair advantage over female golfers, and they need to just get over it. It sounds a lot like that Dave Constantine, or however you say his name, that state assembly rep, Democrat, down in, I think in the, I don't know, Dells area, that said something on the assembly floor about how girls need to try harder in order to compete against biological males. Oh, it's so infuriating, Cory. I mean, I can't even imagine. Did you participate in sports when you were either in high school or college?
Oh yes, both. Both. And any girl who has played competitive sports, they know that that's laughable. We work so hard. We train, we practice. We want to be the best we can possibly be at the sport that we're competing in. And anyone with brothers, anyone who's played against males, knows that we are not the same. And that's okay. Males and females are not the same. Males are stronger. They're faster. It's not fair. So anyone who says, well, girls just need to try harder, they don't get it. Simply. Yes, I played basketball, volleyball, softball. I played softball in college. I hope, I like to think that I was a pretty good athlete, but I wouldn't stand a chance against a guy,
and where are the
someone on the guys' team.
Yeah, where are the feminists? And I mean, I've shared this before to our listeners about, I was a competitive tennis player, and it used to drive me crazy when my husband and I would get out on the tennis court together. And he's athletic, but he wasn't a competitive tennis player like I was. And he well, I don't even know if I want to say this on the air, but he beat me from time to time. And I mean, he's stronger and has more physical stamina. And it used to make me crazy because I'd be like, hey, I played competitive sports. I played in the state high school tournament. I played in college. I played in USTA tennis. And here you are just sauntering out on the court with your Chuck E. T's on. And, you beat me on. I mean, I wouldn't say we ever played a full match. I don't want to give him that much credit. But, there is a difference. And it's really unfortunate that, honestly, there are those on the left that are, they are blind to what is truly going on. And I think they are deliberately being blind to how unfairly women are being treated, girls and women are being treated in sports.
Yes, I think anyone who won't acknowledge that there's a difference between males and females, particularly in the context of athletics, they either are not being genuine or they're completely uninformed. There's really no other explanation.
Cory Brewer, thanks for joining me this morning. I really appreciate your time, and please keep us posted on this issue. And I will be in touch. I know that one of the residents in the DC Everett School District did submit some information to Will for via your website about this particular issue, and I assured her that I know someone would be addressing it. And this obviously is more job security. This will be an ongoing battle that we have to continue to endure. So thanks for your great work. Hope you have a wonderful Labor Day weekend.
Thank you. It's always a pleasure to join you.
Thanks. Have a great day.